This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about how an insurer fought back an insurance fraud and an attempt at arson for profit, and not only succeeded, but was awarded damages. The insured suit for fire insurance benefits was defeated by a qui tam claim made by the insurer based on the Insurance Frauds Prevention Act in Pennsylvania. In the case Lisa A. McCullough versus MetLife Auto and Home, a September 30, 2022 decision of the United States District Court for the Middle District of Pennsylvania, McCullough sued seeking to force MetLife to pay the plaintiff for an insurance policy on the McCullough home, which was destroyed in a fire in 2019. MetLife moved the case to the United States District Court and filed an answer to the complaint along with a counterclaim against plaintiff for insurance fraud. MetLife served the counterclaim on plaintiff's attorney the same month, alleging insurance fraud under Pennsylvania law. Plaintiff failed to respond to the counterclaim, and in March of 2021, MetLife moved for entry of default against the plaintiff, and default was subsequently entered by the clerk of the court. MetLife moved for a default judgment in January of 2022. The court granted MetLife's motion and requested briefing and evidence of any damages sought by MetLife. MetLife submitted a brief and evidence listing the damages and additionally moved for judgment on the pleadings pursuant to Federal Rules of Court 12C. For the following reasons, the court ruled that the Rule 12C motion must be granted, and its motion for a default judgment was granted in part, but denied in part, for lack of sufficient evidence. When discussing a motion for judgment on the pleadings, a court assumes the truth of all of the factual allegations in the plaintiff's complaint and draws all inferences in favor of that party. It does not, however, assume the truth of any of the complaint's legal conclusions. Pennsylvania law provides that an individual commits the offense of insurance fraud if she knowingly and with the intent to defraud any insurer or self-insured presents or causes to be presented to any insurer or self-insured any statement forming a part of or in support of a claim that contains any false, incomplete, or misleading information concerning any fact or thing material to the claim. Although these elements are set forth in a criminal statute, the statute further allows aggrieved insurers to file a civil action against violators of the statute to recover compensatory damages, which may include reasonable investigations, expenses, costs of suit, and attorney's fees, commonly known as a qui tam or whistleblower lawsuit. Additional facts that were presented to the court indicated that the plaintiff set the fire, such as her relocation of important documents were before the fire and the discovery of newly purchased gas cans with residual gasoline in them at her home after the fire. Plaintiff submitted a claim to defendant for the alleged loss as a result of the fire, thereby presenting false, incomplete, and or misleading information concerning the claim and the cause of the fire. As plaintiff has not appeared before the U.S. District Court, the court, by rule of practice, must conclude that there are no disputed material facts. MetLife's factual allegations lead to a reasonable inference that plaintiff committed insurance fraud, and accordingly MetLife's motion under Rule 12C was granted. Having found that MetLife has satisfactorily alleged a civil claim for insurance fraud, the court then considered its damages. MetLife seeks $26,069.01 in pre-suit investigation costs. It provided the court with invoices for the firms hired to investigate the fire in McCullough's home to support its request for pre-suit costs. The court found this evidence sufficient to award the pre-suit costs without an evidentiary hearing. MetLife also sought an additional $29,998.04 in litigation costs of suits and attorney's fees for a total of $56,067.05. However, the invoices MetLife submitted do not indicate if multiple attorneys worked on the matter or only William J. McPartland, Esquire. Additionally, the invoices do not explain how many hours were billed for or the hourly rates for Mr. McPartland and any other attorneys working on the matter, nor are there affidavits to substantiate these hourly rates as the prevailing market rates in the community. Without this information, the court could not determine a reasonable fee for counsel's efforts. Accordingly, MetLife's motion for default judgment is granted in part and denied in part with respect to the damages it seeks, and the court offered to reconsider if provided sufficient detail concerning the attorney's fees sought. An almost total victory for MetLife. In my opinion, insurance fraud, especially an arson for profit, are both crimes and defenses to the breach of contract claims by the insured arsonist. When MetLife filed its cross-claim, the insured and her counsel saw the writing on the wall and refused to participate, or just failed to and ran away. As a result, the insurer obtained a judgment against the insured, which may or may not be collectible. The judge, with a finding of fraud, however, should have referred the case to the local U.S. attorney for prosecution, since arson for profit is one of the, if not the most dangerous types of insurance fraud, where firefighters and the neighbors of the house could have been injured or killed. She should have been arrested. This video was adapted from my blog, Zalma on Insurance, which is free to anyone who asks, at zalma.com/blog. You can subscribe and miss none of the blog postings or the videos. You can also subscribe to my Rumble channel and my YouTube channel, and I'd appreciate you clicking on the like or Rumble buttons as you do. And you should also consider subscribing to my locals community and to my Substack publications. Thank you for your attention.